Thank you. Next is Beth Robinson, Tom Barbera, then followed by Jody Weiner, and then David Buckle and his clients.
Thank you, and good evening. My name is Beth Robinson, and I'm actually from Vermont, and I appreciate you allowing me to come speak with you tonight. I'm an attorney in private practice in Vermont, and from 1997 to 1999, I have the privilege of representing 3 same-sex couples.
Can I actually ask all couples, and we all think, all the speakers, you think you're close to the mic? Some of us actually can't hear you, so eat the mic.
I need to grow is what I actually need to do, and that's tougher.
Sorry about that.
Try that. Thanks. I'll just kind of walk through the aisles. Sorry. From 1997 to 1999, I had the privilege of representing 3 same-sex couples in Vermont in our marriage case, which, like the New Jersey case, ultimately led the legislature to pass. You want me to slow down, too? Yeah. Okay. Ultimately led the legislature to pass a civil union law. I'm in private practice. I represent a lot of gay, lesbian, bisexual, transgender clients, as well as Sorry. I represent a lot of individual clients throughout the state of Vermont. And in addition, I am the chair of Vermont Freedom to Marry. I traveled here to New Jersey tonight to deliver a simple message directly and emphatically, and that is, please understand, and we know this from 7.5 years of experience in Vermont, that the passage of time will not bring the civil union law to parity with the marriage law. No time, no years, no passage of time will eliminate the inherent inequalities built into the separate legal institutions. I've submitted some written testimony, and I ask that that be incorporated in its entirety into the record. I'd like to cover a couple of points from my written testimony tonight, but obviously won't be able to hit all of them. There are 3 areas that I'd like to talk about. The first is we've heard about health insurance. And I want to emphasize that now, even 7.5 years after the civil union law passed in Vermont, I still field calls regularly from individuals whose employers are denying them health insurance coverage for their civil union partners, even when those same employers provide health insurance coverage for married spouses of employees. This doesn't just, the civil union law that we have in Vermont, and I submit the civil union law that you have in New Jersey, does not just put same-sex couples in civil union on lesser footing than our married heterosexual counterparts. It puts us on lesser footing than our counterparts in the state of Massachusetts, where same-sex couples can marry. And the reason is this. ERISA notwithstanding, and I'm not an ERISA expert, and I don't want to argue about whether the law does or doesn't compel employers to provide the insurance, but I will say this. We know that in a civil union regime, the burden of inertia favors discrimination. An employer that wants not to discriminate needs to amend its self-insurance plan to include civil union spouses within its coverage. An employer that wants to keep on discriminating simply needs to do nothing. Likewise, or conversely, in a state in which same-sex couples can marry, the default position under most plans becomes coverage for same-sex couples who are joined in civil marriage. An employer that wants to discriminate would have to take the step that the employer we heard about moments ago took of affirmatively amending its plan. Most companies don't take that kind of initiative. In Vermont, and I've seen a lot of clients in this situation, we have a lot of folks who work for companies that have national plans. They're not likely to tweak their plans to accommodate the needs of an individual state. And so the burden of inertia becomes quite significant in terms of the scope of access to health insurance coverage of Vermonters in same-sex relationships. Just last week, I spoke to a gentleman, Joe, who got a new job for an employer that's based outside of Vermont. His employer said to him, "We can't provide health insurance for your partner," who also happened to be named Joe, notwithstanding Vermont's civil union law, but if you were married legally, we would be able to provide you that health insurance. It's not an unusual situation. Not only does the civil union law put the burden of inertia on the side of discrimination, but I think unwittingly it puts the moral authority of the state behind discrimination. An employer isn't, after all, discriminating against gay people. They're just simply not providing insurance to couples joined in civil union. It's a separate status that the state itself created. In a world, I'll just finish this thought, in a world in which the default option is marriage for same-sex couples, a company would have to take the affirmative step of saying, yes, we provide health insurance coverage for same-sex couples or for couples who are married, but not if they're married to someone of the same sex. And I submit to you that the vast majority of respected companies would not take that step in a world in which the moral authority of the state was behind equality and fairness. Thank you.